Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled 32 Intervale LLC et al. v. City of Burlington, case number 24 AP 391. Representing the appellants 32 Intervale LLC et al. is attorney Leah Murphy. Representing the appellee City of Burlington is attorney Rachel Seelig.
All right, thank you. Counsel for the appellant, please identify yourself and your client, and then you may proceed with your argument. You have 5 minutes.
Good afternoon. May it please the court. I'm Liam Murphy of MSK Attorneys, and I am representing the appellants in this case, who are 12 individual property owners owning 16 dwelling units, which as a result of changes in amendments to both the zoning ordinance and the minimum housing ordinance in Burlington, became pre-existing non-conforming uses, primarily because they could not meet the occupancy requirement, owner occupancy requirement of the minimum housing standards here. We appealed we have submitted a declaratory judgment action with the civil division for 2 reasons. First, the matter involved both zoning and minimum housing. Minimum housing, being under a different chapter, had an appellate review in the civil division. And of course, the civil division, the zoning amendment was in the environmental court. However, despite this court's ruling in Gould, the environmental court has at least twice, if not more, specifically stated that it does not have authority to hear cases that do not involve an act or decision or an appeal of an act or decision under 24 VSA Chapter 117. And that leaves a major gap that the Gould decision, which was followed by the civil division, says that it did not have jurisdiction because this declaratory judgment arose under Chapter 117, and that 4 VSA Chapter 34 grants jurisdiction to the environmental court for matters arising under that chapter. However, the environmental court has limited its jurisdiction to only those matters which involved an act or decision. So other matters that arise under Chapter 117 but are not an appeal or an act of decision have an inability to go to the environmental court and an inability to go to the civil court. This court has not ruled on that issue yet. This court has never determined what the jurisdiction of the environmental court is in regard to matters arising under Chapter 117, but which are not acts or decisions. The court could make that decision, and if the environmental court were to follow the Gould decision and make a decision, then we would have filed there. And in fact, following the Superior Court, the Civil Division's dismissal of this case because of the Gould case, we did file the same action in the environmental court. And there was a motion to dismiss, and it's been fully briefed, but the environmental court has chosen to wait until what this court has made a determination as to whether or not it would have jurisdiction to hear a matter arising under Chapter 117, but which is not an appeal of a decision and an act. And it makes sense to have that authority because there are situations like this where there are many common interests of law among these 16 different dwelling units that could be answered in a very efficient manner instead of waiting for 16 different enforcement actions and then going through the appellate process. My experience over the last 40 years has been when there's a new zoning rule or a new decision, it takes 10 years for that to sort out through the courts because of the iterative process of determining differing factual situations. In this case, a declaratory judgment action would have allowed the court to provide guidance to not only my plaintiffs, but to many properties throughout the state by answering in one context and one hearing many different issues. I believe my time is up.
All right. Thank you, counsel. Counsel for the appellee, please identify yourself, your client, and then you may proceed with your argument. You also have 5 minutes.
Good afternoon, and may it please the court. My name is Rachel Seelig of SRH Law, attorney for the appellee, the City of Burlington. The trial court's decision should be affirmed because appellants brought, as Attorney Murphy described, a garden variety zoning question to the Civil Division, which under Title IV lacks jurisdiction over zoning matters because these cases arise out of 24 VSA Chapter 117. The Declaratory Judgments Act does not expand a court's jurisdiction or create exceptions to the legislature's decision to assign zoning matters to the environmental decision. We agree that there was jurisdiction over in the Civil Division over minimum housing standards claims. The only claim brought under that ordinance was resolved in summary judgment on behalf of the city. The only question before the court today is whether the claim seeking declaratory relief regarding pre-existing non-conforming use can be heard in the Civil Division. And a straightforward application of Gould clearly answers this question, no. The court was abundantly clear that the plain language of Title IV divests the Civil Division of jurisdiction over matters arising out of Chapter 117, that is, zoning disputes. The question is not whether the Environmental Division has jurisdiction, and any ruling on that question would be merely advisory because that is not where this case came from. There's also no gap in jurisdiction here. A declaratory judgment can be sought through the Environmental Division, but again, that's not the question that the appellants raise here. The question is merely, is the Civil Division granted subject matter jurisdiction over zoning matters? The question is not, is there an expansion of that jurisdiction because of the relief requested? Both in Gould and in a case coming out of Newfane, this court has been clear that the relief requested does not expand the court's jurisdiction. This case plainly arrives under 24 VSA Chapter 117 because appellants are seeking a determination that they have a pre-existing non-conforming use. Non-conforming use.
Ms.
Yes.
Selig, what is the case out of Newfane that you have just mentioned?
Yes, it's cited in our brief. It is Chandler versus Town of Newfane. In that case, Chandler was seeking monetary damages arising out of Chapter 117, and this court also dispensed with that case and said that no, that did not create jurisdiction in the Civil Division.
Okay.
Municipalities are empowered to regulate non-conforming uses under Chapter 117. These uses are a creature of Chapter 117. And because of that, a question of how Chapter 117's non-conforming use applies to these appellants' properties is not a standalone question. It requires fact-specific determinations for each property as to whether it would be able to have that zoning status. So this does not fall within the narrow exception for so-called standalone declaratory judgment actions, which is only available when a party under 4472 is seeking a determination of the constitutionality of a zoning regulation or town plan. Because this is not that, but rather appellants are requesting determination as to their status, it is not appropriate for the Civil Division. And I think on that, I will rest on our briefs. Thank you.
Very well, thank you. No, I don't see any questions for you. Does the appellant have any time remaining?
Appellant has 16 seconds remaining.
Your Honor, I think it's important for the court in this case to make a decision about the environmental court's jurisdiction. Otherwise, when a decision is made by the environmental court, we'll be just back up here to answer the same question again. Thank you.
All right, thank you both. Bailiff may call the conclusion of the case, please.
The next hearing for the court is scheduled for